Well, welcome back to the Law&Crime Network. I'm Bob Bianchi, your host for the next couple of hours. We've got a lot of great stories for you. What we just listened to right now, and I think it's fascinating, is the Shara Wright bail hearing. She is accused out of Memphis, Tennessee, of murdering her ex-husband in a 2010 incident, Lorenzo Wright, who is an NBA star, as you can see on your screen right now. So welcome to our Sirius XM listeners. As I always indicate, if you guys have any kind of questions or comments you'd like to ask, please put them on the Law&Crime Network blog there, and start it with @RBianchiESQ so I can just look down real quick and know that you have a question. I'm really excited to have one of my faves of the show here is my guest, Kenney Baden, who is a former prosecutor, criminal defense attorney. We've gone through this rodeo a couple of times, me and you, and I love being on because you got some great skills.
You're my New Jersey man.
My girl, all right. So we're doing it all Jersey today. Listen, Linda, I mean, this is really a fascinating bail proceeding. In fact, I'm involved in one right now where people don't realize how critical it is for the defense to get the client out of jail. And in fact, we're doing some research right now on this case, high-end client, worth lots of money and all that. And the point is that many people, there's a higher statistical percentage of people who are convicted of crimes when they cannot get bailed out because they're sitting in the jail, access to attorneys, ability to be able to talk to your client correctly or properly or in a calm fashion. What are your thoughts about the importance of getting out on bail?
Well, it's very important if you're from the defense attorney to get out on bail. And as you see in cases in certain...
Linda, I'm sorry to cut you off right now, but I just want to let our Law&Crime folks and our Sirius XM listeners know that the co-defendant in this case, an individual who's also charged with assisting in these crimes, is in court right now. He's in the standard jumpsuit, if you will, green jumpsuit. The lawyers are milling about. Right now, nothing is happening inside the courtroom, so I'm sorry for having interrupted you, but I just wanted everybody to know what they're looking at.
Yeah, so as a matter of fact, in many cases, when you're an attorney out of jail and the client's in jail, your calls are taped. So it's very hard to have attorney-client privilege when your calls are being taped, and usually they get turned over to the prosecutor. There's a case going on right now. In some cases, some places don't allow it, but some places do. You can't have access to your client. Everything is being watched. Cameras are watching you. It's very, very difficult to prep a client for a crime trial, a trial of a crime, when they're in jail.
Right, and listen, they're under a lot of stress in that jail scenario. That's a very good point that you're making. They're worried about their safety and their well-being.
Sure.
There's a whole code of conduct that's going on in the jail. And like you said, you have to worry about all of your communications potentially being intercepted. I know as a prosecutor, we solved a couple of murder cases based on phone calls that were going on between the jail and people.
Well, people's okay. Lawyers, I don't think should be.
Of course not, but you know, you always worry about that. In fact, in the case that I've got right now, what really concerns me is that now the defendants don't appear in court. They appear via telephone and teleconferencing, and they actually have us doing attorney conferences between me and my client with that device in the room. And while they can tell me till they're blue in the face that it's not on, it's not activated, it chills my conversation with the client. So it's my hope to get them out, both for their peace of mind, but for proper representation.
And you have to remember that many clients are not guilty of the top count. Maybe they're guilty of a lesser count. So you want to probe with your client whether the facts of the case with them. You want to find out whether or not you should be considering a plea, and you can't do that if they're going to admit to the crime on the TV camera that's being taped and listened to.
Yeah, absolutely. So going back to this specific case with Shara Wright, I mean, this is kind of an amazing case. It's going to be something I'm sure the Law&Crime Network is going to be all over. It's got this NBA star that's murdered. It's a series of events that are going on. But let's talk about the judge. Here comes the judge. This judge was no joke, man. He was all business, and some people have put on there, in particular, I know I got one from one of our viewers, Real WB, who talked about, what's he talking about federal court for? And a number of our watchers are saying, why is he talking so fast? I had to laugh because this is a typical bail proceeding, and I'll throw it to you, and I'll give you my interpretation afterwards. Why is the judge talking so quickly and going about his business in such a toot-sweet manner, as they would say?
Well, Real WB has a great question because I was having a problem. But, you know, bail hearings are pro forma. The judges do it every single day in the criminal courts, and when they have a high-profile case, which is this, they usually have their whole thing written out. They want to hit every statutory point, every case law point as to what they have to set to establish bail. And this is what this judge was doing. He was making a point that in federal court, this would not be a bail case. Therefore, anything he sets may be reasonable in a murder case that involves not only a murder, but a prior attempted murder. And now we have the defendant here who allegedly stopped up a toilet in the jail to try to let her go swimming. I mean, you know, interesting though, Bob, one of the things I took from this is that now that this judge has said she has deteriorating mental health, the county has to be very careful, give her mental health treatment and monitor her, because if anything now happens to her in jail, they are liable.
Right. So let's go. I mean, we can talk about bail forever because there's so much changing in the bail system.
Right.
Initially, it was to assure the appearance of the defendant for the court proceedings because everyone is presumed innocent until proven guilty. But as time has gone on, we've seen other factors come into play, and understandably so, like danger to the community
Right.
is one of those factors. And to that point, the judge he was no nonsense. He was to the point. He was not happy with a number of things that she had done, giving food to inmates, passing items to inmates, unclothed in a jail cell, verbal spats and obscenities to staff members, OC, or pepper spray, for lack of a better expression, was needed to put her down, flooding the toilets. So you are right, there's a mental health issue, but that went directly to the heart of the judge's ruling that she represents a continuing danger to the citizens of Tennessee. And I thought that he had no equivocation about it.
And that's why she was obviously charged, too, so we could bring up these incidents now in her bail hearing for the murder and the homicide case. There's no doubt about that. But going to whether or not she would get bail in a normal case, you know, she's going to have a high bail, no doubt about it. She's going to have a high bail. The problem you have is when you have these little tiny cases, disorderly conduct, and you have driving with, you know, the influence of people get large bails. That's where the problem lies.
Right, right. So listen, it was a fascinating bail hearing. $20 million. She's not getting out. You saw the family in the courtroom doing the fist pumping and the high-fiving and starting to cry.
Right.
Very, very riveting, especially for the first time a family is coming into a courtroom. Seen it a million times. Listen, we're going to go to a break, but you're at the Law&Crime Network, Dan Abrams' production. Hey, it's the only live trial network that's out there that's worthy of watching because you got some real pros like Linda Kenney here who's going to assist us through a number of really important cases. We're going to go to a break, and we're going to come back on the other side and discuss all the fascinating stuff that we have here on the Law&Crime Network. I've got my awesome guest, Linda Kenney Baden, that's with us, and we have just looked at a bail hearing in this fascinating case of Sheriff Wright, and we're also on verdict watch in the Sean Harrison case. I mean, the question is double life or not with this 55-year-old dean of academics, an anti-gun, anti-gang, anti-drugs individual who was on trial allegedly shooting a teen in the head who was 17 years old over a drug-related transaction. The charges are attempted murder, drug offense, weapons offenses, ammo offenses. We're going to get to that case, Linda, because I thought that the closing statements, especially that of the defense attorney, were fascinating. It's really a Jekyll and Hyde. I mean, is this the good guy that he poses to be, or is this guy engaged in a drug distribution scheme where he tried to actually kill a 17-year-old boy? We're going to get back to that shortly, but we're also following here at the Law&Crime Network. Hey, it's the Live Trial Network, Linda. You got to love it because also this case, it's unbelievable. Yasina Sasmas, 34 years of age, from Wichita, Kansas. The victim in this case is a 27-year-old Laura Abarca and her 6-week-old little baby girl that we're referring to as baby Sophia. The charges in this case are first-degree murder, kidnapping, weapons offenses. There's a lot of flesh in this case, but essentially what is being argued is that she went to kidnap this 6-week-old because she had posed to her family and friends that she was pregnant, she had a miscarriage, and she went and abducted this child and killed the mother, and then went back to Texas with that child, posing as if it was her own, indicating that she delivered that child in Wichita, Kansas. We're going to throw to a package to that real quick so that our viewers and our Sirius XM listeners can get a feel and a flavor for this case. Trust me, folks, I've been reading the background on this case. There's a lot more, including another related incident that this woman was involved in. It's every parent's nightmare. While it doesn't happen often, it happens often enough where people are actually stealing children and either passing them off to third parties and selling them or taking them as their own because they can't have their own child. It's so unfortunate and regrettable. Let's take a look, and we'll discuss it when we come back on the other end of the package. Linda Kenney Baden, I mean, this case is, while she's saying it's an accident, it just was noted in that great package from our producers here at the Law&Crime Network. She was actually out on bail on another offense. She was here illegally. You know this is going to stir up a lot of controversy about it. When I was prosecutor, I had a number of these kinds of cases where serious crimes were committed by people who were released on criminal charges that weren't here illegally. In any event, I mean, what do you see? I mean, as a prosecutor, if there is the kind of case, and our folks should know this, listen, we're human beings. Many cases are run-of-the-mill, and it's kind of like the mail coming in, and then all of a sudden you get a case like this. As a prosecutor, you kind of salivate. What do you think, Linda?
Well, this breaks my heart, this case. And we see a lot of these, Bob. That's what's amazing to me about women who kill other women and take the babies. Or there was one that ripped the baby out of a womb, if you remember, a few years back. There has to be some kind of mental psychiatric disease that is just specific to this kind of crime, and I really think there should be a specific law relating to it too. A federal law even. No, if you get convicted, you're in jail forever, no bail, that's it, goodbye, so long. And it could be federal because when the child went across state lines, remember.
You know, Linda, I want to talk to you a little bit about when the feds decide to pick up a case and when they don't, because it is so erratic.
Right.
But before we do that, we have some seriously important top news to get to at the Law&Crime Network, and after you listen to that, we're going to come back and maybe we'll bat that around a little bit. And of course, to our Sirius XM listeners, thank you for always supporting us on our Law&Crime Network. Folks, if you have a question for me or if you have a comment you'd like to make, please do it. Start with @RBianchi ESQ, and me and Linda will try to answer any questions you may have. Well, I'm back here on the Law&Crime Network with Linda Kenney Baden, and listen, I'm embarrassed to say this, but I have to actually put makeup on, and I don't know how to do it. And you got to love Linda. She's not only a great prosecutor, great defense lawyer, a great TV commentator, but there she was trying to help put it at least on the forehead. So we're at the forehead, right, Linda?
I want to know how the forehead looks.
And we're going to move down. We're going to move down because when I'm on the Law&Crime Network and I'm talking about murder and abduction, I start to break out in a sweat. I love this stuff. So thank you for helping me out here with this great makeup stuff. So listen, we were just at a point that I think is important in this crazy case of Yasina Sasmas, who is charged with kidnapping little 6-week-old baby Sophia and killing her mother. Oh my God, it's so bad. But we were talking about, you know, if there's transportation of this minor, this child across interstate lines to Texas. The FBI did assist in the actual capture of her, and I've always found it confounding because I've got one right now as a defense lawyer myself. What you wonder, why do the feds decide to pick up some cases and not pick up other ones? Because to me, this is the kind of case I'd imagine I'd want as a federal assistant United States attorney. What do you think?
Well, this is a perfect case, right? Because this is a person who was here improperly, a person who killed a woman innocently, took a child, crossed state lines, went across state lines to do the homicide if she is guilty, went across state lines to kidnap the child if she is guilty. So this would be a perfect case. But there are rules and regulations about when the feds can come in, and for some reason this case apparently did not qualify.
I've always found when I was the head county prosecutor, we worked on joint investigations many times with the feds and our own state agency, and there would always be this question about what jurisdiction was going to pick up the case. I've always thought that sometimes it can, as a prosecutor, it's a force multiplier if you have like the Durst case, if you remember that case, both federal charges and state charges, because boy, that breaks the back of a defendant. They're fighting two battles, and it's not double jeopardy because oftentimes the federal charges read differently than the state charges. So while they're similar, you can be prosecuted for both, and that generally forces plea offers in my experience.
Well, we saw that, remember, in the Oklahoma City bombing, that one of the defendants, not Timothy McVeigh, but one of the defendants was charged both federally and both in the state prosecution for homicide. So you can do that because it's two separate jurisdictions.
Right. So listen, we're also on verdict watch in the Sean Harrison case. 55-year-old, quote-unquote, reverend, the dean of academics, anti-gun, anti-gang, anti-drugs individual. You see a picture of him up right there looking the part in front of the community. But the question is, Linda Kenney Baden, is this a double life or not? He is alleged to have shot a 17-year-old teen in the head because of a drug-related transaction. The charges are attempted murder, drug offenses, weapons, and ammo offenses. So our viewers and Sirius XM listeners know, in this particular case, a number of significant items were actually recovered on the execution of a search warrant against Mr. Harrison, and that included guns, ammo, a significant and sizable quantity of marijuana that the state's prosecution's expert indicated was possessed with the intent to distribute, a ledger, paraphernalia, and eventually in either the home or in another location, some cash that was recovered. So these things don't look good. Linda, we're going to go to, I thought these closings were fascinating, defense part of the closing in this case. And on the other end of that, we're going to come back and we're going to discuss what tactics the defense attorney used in this case. Remember, this guy comes with a lot of reputation into that courtroom, and that could raise some doubts to the jurors. Let's see how the defense attorney did. Listeners, welcome aboard. We are listening to what was the closing statement, or part of the closing statement of the defense attorney in the Sean Harrison case. This is a case with a 55-year-old reverend who is also a dean of academics, supposedly a mentor to many kids, advocating for anti-gun, anti-gang, anti-drugs, who allegedly shot a teen in the head that he's on trial for. The defense attorney was trying to explain in that there was no motive for this and blaming others. There were two other individuals involved in this case for the drugs and the guns that were recovered. But interestingly, during that closing statement, he basically told the jurors, and I was talking with our guest, Linda Kenney Baden, that he admitted that he was responsible for those things, yet find him guilty of that, but don't find him guilty of the more serious crimes. Linda, what do you get with that tactic of the defense attorney? Is it a good one? And by the way, have you ever seen it before? Because I've only seen this tactic of saying a client is guilty in a summation only recently with great frequency. What are your thoughts? Yeah, I've only seen it recently. It's now apparently the thing to do to get credibility with the jury, to admit some things and not others here. But I'm not sure how much it controls here. Look, if I'm a juror, I find the defendant guilty on the drugs and the guns. No issue about that. The homicide, here's what the defense attorney, in my opinion, should have focused on. Number one, the victim never said it was Sean Harrison when he was first shot. Okay. And secondly, you know what bothers me is that the prosecution and the defense never did the analysis where you could see, you know how big the victim is. You can know what other things around the area is, see how big he is, and see whether the person shot him matches the height or comes near the height of the defendant. And no one did that. And I, for the life of me, I don't understand why. Yeah, but you always got to worry when you do something like that. If the height don't fit, you must acquit. You know, how many times have we sat across the table with a piece of evidence like a jacket or a glove? We remember an infamous case with a glove. Yes, we do. And you sit there and you stare at it and you look at it and you say, will that fit the guy? Won't it fit the guy? And to be honest with you, both sides are so afraid of that piece of evidence. But the jurors are going to try to do that. Yeah, they're in the jury room. They're going to say, okay, let's see what we can investigate, because jurors like to search for the truth themselves. And let's see if we can figure out, could this say he had been the shooter? Because we know that the defendant preys on young men. They know he preys on people that have problems and kids that have problems. So could he have hired this person to help him and then be the shooter himself? Sure, absolutely. Right. Did they prove it? I don't know. You know, this is why I love the Law and Crime Network, because we get to break trials down live with people who've got some significant experience. I just got to give our viewers and our XM listeners just a quick anecdote about how clothing was big in this case. They actually, in the Harrison case, put an expert on that tried to use videotapes to match what was shown on this grainy video with the potential clothing, with the clothing that was recovered, and tried to make that comparison. But Linda, I actually had a case one time where the victim in an armed robbery on a very weak identification, and I was really worried it was going to be a not guilty indicated. The guy was wearing, you remember those old 8-ball jackets that had that big 8-ball on the back? Yeah, oh my gosh. I remember a Ouija board. I'm going back 80s now. This is like 80s style. And he said, and it had a rip in the jacket, and you cannot make this up. In the middle of the trial, after the victim testified and got hit pretty hard by the defense on a cross-examination, the defendant walked into the courtroom with an 8-ball jacket with a rip in the area that the victim had identified. And you can imagine the mayhem when I'm asking the sheriff's officers in front of the defense attorney to take his jacket off him. It caused commotion, and I am convinced that is what convicted him. He walked into the court with the very jacket the victim identified. So clothing can, you know, you never know what can happen in the wacky, wild world of trial
law. If I'm the defense attorney in that one, you know where I am. I am under the table. I'm going now. You know?
And that's a great point. You know what? He had been in that courtroom for a while, and as trial lawyers, either as a prosecutor or as a defense lawyer, I would always train my attorneys, or when I lecture, you have to be cognizant of everything that's going on in that courtroom. You have to have eyes in the back of your head. Are there people that are communicating to the jury improperly? Are there people that are doing something? Is the defendant doing something or reacting in a certain way? It may slow you down and cause you to look so that the jury looks at it. You really got to know what's going on. So as a defense lawyer, I'm very conscious of how my client's appearing. Certainly if he walks in with a piece of evidence that identifies him as the armed robber, I'm going to be operating quickly to stop that from happening.
Yes.
Well, listen, again, folks, we're going to go to a break, but Law&Crime Network, a Dan Abrams production, Sirius XM listeners, love having you on board. If you guys have any questions at Bianchi, Bianchi, ESQ, put them up on the website and we'll try to answer them. Even any kind of comments we may find interesting to pass along to our other viewers and listeners. And we're going to be coming back on the other end of the break and discussing these fascinating cases. Fascinating bail case we had, this crazy case with Yasina Sasmas, the kidnapper/murderer, who is going to be going on trial, and we are on verdict watch in the Sean Harrison case, which we just discussed. Welcome back to the Law&Crime Network, and welcome to our Sirius XM listeners. Once again, I got Linda Kenney Baden here. I have to thank her. She is taking care of business with me so that I don't look so shiny in front of you. She's patting me down with this thing. I feel a little emasculated here, Linda, but you are showing me the ropes.
I'm your partner in crime here, Bob.
You are taking care of business. You're flicking things off my face. Thank you very much. But listen, folks, we are here, and we're breaking down. We're on verdict watch for the Sean Harrison trial. This is the trial where this Reverend Dean of Academics, anti-gun, anti-gang, and anti-drug person, at least that's what the community thought, but the prosecutor says, whoa, slow that roll down a little bit. This is a Jekyll and Hyde. This is a guy who is leading a double life. He, in fact, was soliciting juveniles and teens in a drug distribution scheme inside his home. When they execute the search warrants of Mr. Harrison's 51 years old, they find drugs, they find guns, they find ammo, they find ledgers. There's cash found in this case, and they allege because of something gone squirrely, as we would say in the business, he actually tried to kill by shooting in the head a 17-year-old teen who actually lived and testified very dramatically that that's the guy that shot me. And Linda, there was some serious, at least evidence that was gathered by the cops who did a very thorough investigation in this case of video surveillance. We're going to talk about that on the other end. We're going to go to a break real quick, and then when we come back, we're going to do a little bit of discussion on that, and we're going to probably look at it. Yes, so we're going to, actually, my bad. Before we go any further, we are going to go to the prosecutor's closing statement in this case. And when we come back on the other end of that, myself and Linda are going to break down, did the prosecution prove beyond a reasonable doubt to the satisfaction of all 12 jurors that, in fact, what looked on the outside as a person who was a community leader was, in fact, a person who was involved in a drug distribution scheme with teams. Let's check out the prosecutor's closing. Welcome back to Law&Crime Network, and welcome to our Sirius XM listeners. You are listening to the prosecution's closing statement in the Sean Harrison case. This is the live trial network, folks. When you're seeing these cases, you're seeing it all. You're seeing the openings, you're seeing the closings, and you're seeing the good, bad, and ugly from all the witnesses that are testifying. Gotta love the network. So here we are, finally. The lawyers are at the final stage, their last ability to argue to the jury. This is Sean Harrison's a 55-year-old man, a dean of academics, a person who claims to be a reverend, who was supposedly a youth person who assisted youth in anti-gun, anti-gang, anti-drugs. Prosecution's question, double life or not? That's what this jury has to decide, because he is accused of engaging teens and juveniles in a drug distribution scheme and actually attempting to kill a 17-year-old teen by shooting him in the head, who actually survived and testified at trial. I'm here with Linda Kenney Baden, and we were discussing prior to this the fact that there were drugs that were recovered. You saw the prosecutor very boldly sticking them up up there. I love that. Listen, Linda, I've seen prosecutors who have great pieces of evidence like that and leave it stuffed in that little box. That speaks louder than words. I thought he did a great job demonstrating that and making a pretty powerful argument. What are your thoughts?
Well, I love the exhibits and the demonstration of the marijuana, obviously. Now, in many states, though, Bob, you can't do that. You have to take a picture. The drugs have to be left in the back. You know, you can't bring the actual marijuana, the drugs, into a courtroom. So prosecutors sometimes use pictures of the marijuana. Now, in a normal case, marijuana wouldn't really be that important, right? Because it's legal in most states. But here it wasn't. It was being distributed by somebody who should have been a mentor to these kids. I think he's guilty. I think the prosecution's proved it. But the murder could be a little iffy in that jury room.
Okay, Linda, great. Listen, we're listening to the Sean Harrison trial. That was the prosecutor's statement. We're going to go to a quick break. When we come back from that, we're going to listen to another clip of the prosecutor's powerful closing statement in this case. And we're going to discuss it with Linda Kenney Baden, one of my faves here, my Jersey girl, former prosecutor and now criminal defense attorney, has a career very much like my own. And listen, you guys, when we come back, we're going to hear some riveting testimony and some great analysis from Linda. Thank you. Back to the Law&Crime Network. I'm here with my guest, Linda Kenney Baden. What we were looking at is the prosecution's closing statement in the Sean Harrison trial. This is the question, double life or not, or at least as I'm putting it, Linda. A 55-year-old dean of academics who's on trial, a person who was a youth counselor, anti-gun, anti-gang, anti-drugs, and allegedly shooting a 17-year-old teen. This is out of Boston, Massachusetts, which I think you have some familiarity with.
Just a bit.
Just a bit, right. And he's charged with attempted murder, drug offenses, weapons offenses. Prosecution putting on a very powerful statement there, and I want to get your opinion about it. He talked a lot about this text, and he talked also about his demeanor. This is a common thing prosecutors would do. Does this appear to be the demeanor of a person who was to find this out? And he kind of started talking about how he clutched his chest when he found out that the 17-year-old boy, Luis, lived, and that was some sort of indication to the prosecutor that he was nervous because he knew that there was a witness. And just to recap the prosecution's argument here, he's saying in this text, get out of house, was respect to two other individuals who were originally co-defendants in this case but thrown out for legal reasons. Nevertheless, that evidence got introduced. And in addition to that text, he's basically indicating, quote unquote, pray for me. And the prosecutor's asking a rhetorical question. Why would you be saying pray for me? And in addition to that, Linda, and we'll get your thoughts on all of this, it says that he lied to the police in saying he didn't know where Lewis lived. Why would he be saying that when it's proven that he did know where Lewis lived? All this deceptive conduct the prosecutor's arguing is to get himself out from under trouble and use the very term that the judge will use in the jury charge, that it shows a quote-unquote consciousness of guilt. What are your thoughts?
Well, Bob, let's talk about a closing. What is a closing here? All right, a closing is to give the juror the best arguments. Jurors that are on your side can go in and argue against people that may be saying not guilty. And that's what this prosecutor did. For instance, clutching your chest, oh my God, pray for me. That could be two interpretations, right? Maybe he's upset because he failed this kid, or maybe he's upset for this kid. But the prosecutor, no, he's acting. He's really upset for himself because he's going to get charged with murder. And then to boot it, the best part to me of this closing when he said he lied about where he lived, because it goes to show you that if this man could abuse these kids by using these kids, he then wants to have somebody take this young man out because he failed by shooting him in the head. That is terrible. And the defense and the jury wants the jury to hate the defendant. And right now, I hate the defendant. So he's doing a good job.
Yeah, I think he is. And, there's something about the way that he's presenting the evidence and using those common sense arguments, which I say all the time to trial lawyers. Keep it simple, stupid. Right. Stop being the smartest guy or girl in the courtroom. You're selling a product, if you will. I hate to say this. You are a case to a jury, and what they want is not fancy discussions, maybe not even expert testimony. They want to ask themselves, based on their own gut, common sense instinct, are these the actions of an innocent person, to be lying to the police about where Louis lives, to have all this stuff inside of his house, to have this text that's saying, please pray for me. And it's funny you bring up, how do you interpret clutching the chest? I had a murder case where that very thing happened, and they sent the guy to the emergency room because they believed that he was actually having an anxiety attack, having witnessed the corpse at the time, when in fact it was an anxiety attack because we later proved he was the person who actually murdered him. Ooh. But that's a little bit subjective, right? The other stuff I think is more powerful to a jury in terms of common sense. That text hurts bad.
That's right, but that's a subjective where the prosecution or defense, whatever they're doing at closing, comes in, because you've got to give your argument out to those jurors, right? So yes, common sense is important. What I would say to the jury, it's when you have somebody's argument you want to discount, it's common sense. This is nonsense. This is not common sense. One of those things. You keep it simple to that jury and use that dichotomy. Is it common sense or is it nonsense?
Yeah, they're very good. And I would always say that to the jurors, like, one of the reasons that we hired you here, we brought you here, you're the only independent body, is because of that gut instinct you have. You know life. You have life experiences. You can wash up what's happening in this case and ask yourself whether or not it makes sense to you. And I think that those comments resonate with the jury because it resonates with something that jurors have, common sense. And just as before we go into, we want to go look at the victim's testimony, because I want to talk about that in a second. But, you know, one great defense lawyer I knew when I was a young assistant prosecutor, I had won a case, Linda, and I left my evidence book up in the courtroom. It was Friday. The courtroom was dark. I opened the door, and there he was, this defense lawyer. You probably know him. He was standing, looking inside an empty jury box. I actually startled him. He was so concentrating inside that box, and I said, Bill, what's going on? And he turned to me, he said, you know something, Bobby? He goes, you know, I think I'm probably as smart as any single juror that was in that jury box. But I've come to learn after many years of trying cases, and this was a greatly skilled trial lawyer, that collectively, their collective wisdom and intelligence just blows me away. They got this case right, and I didn't. And I think that there's a lot of truth in the collective deliberation process, don't you think?
Yeah, there is. And usually jurors try to do the right thing. I mean, you may get one juror who's a stealth juror, has an agenda, and that's happened to all of us, okay? But they try to do the right thing. But depending on what you're looking at, you really do want a jury, whether you're prosecution or defense, to honor the beyond a reasonable doubt. Because if you're the prosecutor, you want to prove that case beyond a reasonable doubt. And if you're the defense, you want to put the prosecution to have to prove the case beyond a reasonable doubt to the jurors. And the jurors will take common sense and interpret the evidence in the way they see fit.
Right. And of course, one of the most compelling pieces of evidence that you can have in a case, especially an attempted murder case, is the victim themselves. And Louis Rodriguez actually testified. Louis Rodriguez testified in this case. This was the young man, 17 years old, that supposedly is engaged in this drug distribution scheme, who Mr. Harrison is alleged to have shot in the head, survived, testified in court. One of our viewers on the Law&Crime Network, who blogs often with us last week, I don't remember exactly the moniker, but he raised an interesting question. Why would the 17-year-old boy lie about who it was that shot him? And I think that that is a powerful statement to be made. What are your thoughts on that?
Well, he could be scared. If you're defense, he's scared of the other kids, the one who took him into the bathroom and was pummeling him. He's scared of other kids. That could happen, and the other kids are out. So that's why he could lie. Okay,
so let's go to the clip and listen to the testimony of the victim. And on the other end of it, I'll come back here with my great guest, Linda Kenney Baden, and we'll break it down for you. Welcome to the Law&Crime Network and to our Sirius XM listeners. I'm here with my guest, Linda Kenney Baden, and you are watching the victim testimony. Louis Rodriguez was a 17-year-old boy at the time who was shot in the head and survived. You could see his physical deficits as he's testifying before the jury with his mouth. It's a miracle he survived, and he is testifying against Sean Harrison, 51-year-old reverend, person who was a youth counselor, anti-gun, anti-drug, who the prosecution says was leading a double life and in fact was using juveniles engaged in a drug distribution scheme, and that as a result of something that went wrong during that scheme, that he actually tried to kill Mr. Rodriguez. The prosecution's putting on a compelling case. Linda, what are your thoughts in terms of the credibility, the appearance, everything that you're seeing from this young man as he testifies in court?
Well, when you have a victim in court, it's very traumatizing for the jury. And for a defense attorney, you have to be very careful because you really can't attack the victim too much. He, to me, seems very, very believable when I look at him. And that's how jurors are going to assess him. You know, and what gets me is that he talks about the Rev. I didn't say right away, but I said the Rev. I mean, this is a man who had custody and control over these young men who could have helped them be better people, but he picked on them to use them. Now, you know, in Jersey, we have under the sex abuse statutes a higher degree of crime when someone's in your custody, care, and control. There should be a higher degree of crime when kids are being abused like this by the person, by the Rev, by the student leader, teacher who's supposed to be helping them. It's really a traumatizing case for everybody.
Right, and the prosecution has done a good job in the closing statement. Of course, you can only do as good a job as the facts that you have as a prosecutor, but he's putting building blocks together. And the way the case is being constructed is we got the victim gives testimony. Why would the victim be lying about who shot him? That's part one. Of course, there could be reasons, but it's not likely, the prosecutor's saying. Part two is what was recovered inside this quote-unquote Reverend Mr. Harrison's home, which are drugs, a significant quantity of marijuana, ammunition, guns, a ledger that would appear, based upon the expert that the prosecution, and I think common sense, presented, would be a drug-related ledger, and cash. And then, of course, the third piece to that, which we just heard, was the prosecutor summing up about these text messages, which just are inconsistent with an innocent person, especially "pray for me," "get out of my house," and those kind of things. So each building block together is trying to build one piece of credibility into the other one as a kind of mosaic, if you will, of proof beyond a reasonable doubt. Listen, we're going to go to a quick break. You're at the Law and Crime Network. To our Sirius XM listeners, we are on the Sean Harrison Alert. This is the live trial network. You're listening from stem to stern, a case, and with great experts like Kenney Baden breaking it down with us. On the other end of the break, we're going to listen to a little bit more of that compelling testimony from Luis Rodriguez, the 17-year-old boy who was shot in the head, and come back on the other end and break it down with our great trial experts. Welcome back to the Law and Crime Network. What you were listening to is State versus Sean Harrison out of Boston, a case where Mr. Harrison is alleged, at this point in time, alleged to have committed an attempted murder on that young man you just saw there, Luis Rodriguez, when he was only 17 years of age. Mr. Harrison is an individual who they are saying was actually a Jekyll and Hyde, living a double life while he was working for the school, working with police, working as a community leader for anti-gang and anti-drugs. In reality, he was engaging young teens in a drug distribution scheme. He had significant quantities of marijuana recovered from his house upon the execution of a search warrant. Guns, ammunition, what appears to be drug ledgers, and cash were produced during this case. Some significant texts that the prosecutor that we had just previously shown to you, which would show some level of consciousness of guilt by Mr. Harrison. And I'm with my great guest here, Kenney Baden, who was talking about her striking comments about youth and how these crimes should be elevated. You know, Linda, you were also seeing this boy, that he was also the one that was being harassed in the school, and there was a video presented by the prosecutor where he was pushed inside of a bathroom. And we've done this long enough to know, man, some of these juveniles are involved in some really bad stuff. When I was a juvenile prosecutor myself, but yet there was some vulnerability or innocence to them, or when you knew them on a personal level, you could actually like them, even though they were involved in things like drug dealing and gang-related activity. They're kids.
Right. And what is striking here is that this reverend was supposed to take care of them, these at-risk kids. This is an at-risk child. Let's not forget this. Look at this video.
Yeah, we're looking at the video right now for our Sirius XM viewers.
He's being pushed into the bathroom and about to be pummeled by other students that also were involved in some way with the Rev. And you see now he's got physical deficits. Apparently it was told that he's partially deaf in one ear. He can't move if you can't see him, but he can't move one side of his mouth, almost like a little bit of a stroke victim here when you see it. And yet he's very poised on the stand. It's amazing he lived. But he was supposed to be taken care of by this school and by this reverend. And this reverend instead accused him of taking marijuana and stealing from him. So now you have a motive. So remember, even though the prosecution, Bob, doesn't have to prove motive, when you have one, it's so much more powerful.
Sure, absolutely. Listen, we got a couple of questions I just want to get to, or commentary that were made by our watchers on the Law and Crime Network. And again, we appreciate you guys sending in your commentary as well as any questions you may have. One of the questions was interesting because it's kind of a follow-up. It's by BB 314, a follow-up to prosecution. And the question is, what happens to all that pot? What happens to all these drugs? You know, it's a really good question. Because there's a huge process that occurs with regard to the destruction of evidence, because in days gone by, somehow, Linda, I'm not even making this up.
Yes.
When we were trying cases back in the day when I was a young assistant prosecutor, we just used to leave the drug and gun evidence in the clerk's drawer inside the courtroom that was unlocked. But there is a much more sophisticated procedure to that.
Yeah. Now, as a matter of fact, the evidence is destroyed after a certain period of time if it's not a murder case. And drugs are destroyed if it's not a murder case, once all the appeals are passed and all that, especially drugs. But you got to be careful, because there have been cases where somebody in the police department or associated with has stolen those drugs out of the lockers, as you know.
Absolutely.
And then they get prosecuted. So you have to be careful. And that's some of the reasons early on they didn't send drugs in with the jurors, because they were worried that a juror would if there's cocaine. Well, let me just see. Does this look like cocaine here? And all of a sudden the jury, then you have a mistrial going on. So you have to be careful when it involves contraband.
Listen, when I became the governor-appointed prosecutor up there in Morris County, one of the greatest pieces of advice given to me by somebody who I have mad respect for in the prosecutor world said, Bob, whatever you do, don't give yourself any access to the evidence locker or have any involvement in the evidence locker or ever go inside the evidence locker. When I was a young assistant prosecutor in another county, when I was training, they lost some serious drug evidence, and they had to take out literally every piece of evidence and put it on the entire floor of a garage, empty the garage, because so much evidence was misplaced. It's a common thing that happens, Linda. I agree.
Or evidence can be stolen. I had a case once where somebody was wearing a shirt. It was in the police department. They took it over a defendant, and they hung it up to dry, not a non-secure area, and someone came and swiped the shirt from them. So you know what happens. So you have to be very careful. These may be anecdotes, but they're anecdotes because they happen, and you have to respond to them by having strict procedures.
Right. In most places, just to answer BB 314's question, there is a process that after, as Linda indicated, the appeals are exhausted and the evidence is no longer legally required, that you actually have your evidence custodian that would give a whole list of drugs and things that need to be destroyed. It actually is transported through a chain of custody. It's very rigorous. There's a number of checks and balances to a burn facility where this super unbelievable burner basically just melts everything, and including everything, including metal and what have you. But actually, it takes a long time until all those appeals are exhausted. And keeping and maintaining evidence in old cases because you can't legally destroy it at the time is a major problem with police agencies and prosecutors' offices, because we don't have enough storage space. At least that's what I confronted when I was the county prosecutor. So that could lead to sloppy practices. But that's a great side curve question here that you can only get answered, Linda, on the Law&Crime Network, the live trial network. You gotta love it. Dan Abrams production. Hey, to our viewers, keep those questions and comments coming. For the person who asked for me to run for president, thanks, but no thanks. Being a lawyer is a far more respectable and honorable position. For Linda, for putting my makeup on, you gotta love this network. Listen, we're gonna jump back on a serious note to this victim, Luis Rodriguez's testimony and the cross-examination of him. What do you guys think? Is the prosecutor scoring points? Because so far, I think the kid's doing a pretty good job. Welcome back to the Law&Crime Network. My name is Bob Bianchi. I'm hosting for a little while longer, and to our Sirius XM listeners, welcome aboard. We are looking at the Sean Harrison cross-examination of the 17-year-old boy who Mr. Harrison is alleged at 51 to have shot in the head. He survived, obviously, and is testifying, being cross-examined by the defense attorney. The prosecution's theory of the case: this is a double life. Mr. Harrison was a youth counselor, anti-gang, anti-drug person, but yet behind the scenes, behind that veil, behind that cloak, was a man who sinisterly was engaging juveniles and teens in a drug distribution scheme, and something went wrong. And as a result of that, at the hand of Mr. Harrison himself, he shot and attempted to kill Luis Rodriguez, who we were just listening to testifying. So the cross-examination, Linda Kenney Baden, my great guest here, former prosecutor, prosecutor, defense lawyer, makeup artist, mom extraordinaire, probably a great cook. I don't know. She's got it all. But nevertheless, she was listening to this, and we're just really compelled by how this young man is handling the cross-examination here. And it's a really tactful thing when you're doing this as a defense lawyer. How hard do you go after somebody? How easy? You got to have multiple speeds as a good trial lawyer. And this kid is pretty unflappable. He's pretty straightforward. He's testifying for our Sirius XM listeners with a clear market problem with his mouth that was caused as a result of the shooting. And sometimes, Linda, you need to be careful that you don't go too hard, because nevertheless, this kid was shot. What do you think of the demeanor of the defense lawyer, and what do you think in terms of, is he scoring points?
So what do we have here, Bob? We have it important that indeed this young man could take a knife out of his pocket after he'd been shot and think about whether or not he would be charged by the police. That's important. And that's what the defense should go on. All right? He didn't identify the Rev at that time when he was immediately shot. Those are important pieces. But sometimes when you have important pieces, you can't attack somebody like they're a mafia informant, especially when you have a kid. And even though he may be an adult technically, he is still a juvenile here. So you have to do it in a diplomatic way that you don't anger that jury that you're treating this victim like that. Now, in my opinion, that may be a real issue here that the jury could find. Now, other jurors could say, well, I like defense attorneys that are rah, rah, rah. But you have to do it in modulation, and you make your points in modulation. I don't know, Bob. What would you do?
Well, you know, Linda, we're really deep into a nuance. This is why you got to love this live trial network here, because guys like me can talk about our backgrounds. This is what we do as trial lawyers when we're trying a case. It goes back in my mind, and I think most things should be taken experientially. It's different than a book. Courtrooms are a place where jurors are watching whether they like you, believe you, trust your witnesses. What do I think? I can do it by an experience I had with a grandmother who was testifying, elderly woman, very dainty, very proper, who got up and testified, I believe, lied as an alibi for her grandson. And I'm an aggressive, passionate trial lawyer.
As we are.
But with the right witnesses, if you're going to lie to me, if you want to get in my face, I'm going to take it one step greater than you, because I want to make sure I'm not alienating with the jury. But what did I do with that grandmother? And I think that it made even a greater impact when, having seen me that way in court, I walked up to the woman and I said, ma'am, thank you for being here. You love your grandson. You don't want to see anything bad happen to him. Thank you. I have no further questions. And I let her off the stand. Jurors afterwards said, you made such a powerful point. You said what you needed to say, that she had a bias, but you didn't beat her up because she was a grandmother testifying for her grandson who couldn't understand that. Same kind of thing with this case.
Right.
The kid's a victim. He's been shot, no matter how you look at it. He's answering the questions respectfully. He's poised. I don't know, that really aggressive tone. Like you said, he was getting the point out. You didn't identify the Reverend when the police were there. Points scored. I don't know whether or not the demeanor, we may be nitpicking here, but I would have backed down a little bit on the tone.
Well, yeah, but that's what jurors look at. They're looking at everything. You know, when you're trying a case that's in a courtroom that's on television, you have to be very aware of the cameras. But you should be very aware of the jury when you don't have any cameras in the courtroom. And so being aware of what that jury's doing, and maybe the jury is responding good. But I always, as you do, Bob, make sure that I have the jury in my corner. If somebody attacks me as a lawyer when they're on the stand, believe me or not, I can be really tough. But on something that's a kid, you got to do it with a little bit of just caring, a little bit of caring, and you can get your points out with caring as much as you can by being.
Yeah, and again, we're going back to the trial tactics, and this is, again, why we love this network, is that you really get to talk about what goes on inside that courtroom. And I've been training lawyers, as I'm sure you have, for many, many years, and I try to explain to them, you've got to see the bigger picture of what it is that you're doing. You have to understand, use your common sense, tell the jurors a story, make it believable. You can never lose credibility, and you need to use all the skill sets possible. But what I see a lot of times with lawyers, Linda, is that they tend to paint by numbers, I call it, or they have a script in their mind about what they want to ask, and be damned the answer to the question you're getting. They're going to go down. I've literally watched lawyers in cross-examining a defendant who is about to admit guilt under cross-examination stop them and say, I did not ask you that question, sir. And then all of a sudden they lost the opportunity of that testimony. It takes a lot of flexibility to be a great trial lawyer.
Well, just like the viewers here and the listeners here are listening to what we say, okay? A jury is listening to everything that happens in that courtroom, and you have to listen. If you're the defense attorney or the prosecutor or any trial, you have to listen to what's happening. Very important, and that's why everyone's watching us.
Yeah, big amen to that. Listen, folks, you're listening to some of the testimony in the Sean Harrison case, a 51-year-old minister accused of having shot that 17-and-a-half-year-old boy that we saw testifying, Luis Rodriguez. We're going to throw to a real quick commercial break. You're at the Law and Crime Network. Sirius XM listeners, keep on listening, and we're going to talk more about this case when we get on the other side. Welcome back to the Law and Crime Network and to our Sirius XM listeners. Thank you so much. You're at the only live trial network that's taking a case from stem to stern, as we say in the law, and analyzing all the nitty-gritty with some great trial analysis with my great guest, Kenney Baden. This is the Sean Harrison trial. We are on verdict watch. We've been watching some of the summations of the prosecutors and the defense lawyer. We've been recently looking at the clip with Luis Rodriguez, who was a 17-and-a-half-year-old boy at the time, who was shot in the head allegedly by Mr. Harrison, who was 51 years old, and lived and was testifying against him, alleging that this man was living, the prosecution's theory, a double life. He was a Jekyll and Hyde. His public face was one in which he was an anti-gang and positive youth counselor, and on the other side, the prosecution is saying he really was a sheep in wolf's clothing, that he was preying upon these juveniles in a drug distribution scheme. And Linda, there were significant quantities of drugs that were recovered at his house, at the pastor's house, significant, with the intent to distribute. I don't think there'd be any doubt about that. Guns, ammunition, there was cash recovered in this case, a drug ledger. It looks kind of like that evidence is pretty solidly against the pastor in this case. But listen, there was also video surveillance, Linda, and I found this surveillance to be really quite extraordinary, and we're going to try to narrate it a little bit through with our Sirius XM listeners, and so that you can kind of get the point of what's happening. They had captured, the police will do a canvas typically in an investigation, and they will try to capture all the videos. The expert kind of compiles that massive amount of videos to come up with a timeline montage so that it's understandable to the jury. And you see a lot of activity going on, supposedly the shooting itself. And we're going to watch that. And while we do that, I want to narrate and ask you a question about something I thought the prosecution did that was very odd in this case in terms of the video vis-a-vis the victim, Mr. Rodriguez. So let's take a look at some of that video right now. Okay, so we are going to be, I guess, looking at some of that video. I'm not really certain, but for our Sirius XM listeners, when we do that, yep, we have it going on right now. What's happening is in the courtroom, Linda, your typical thing, the lawyers can't get the computers to work in order to get, well, they're great devices, man. When it's not working, you're just sweating in front of that jury. That's what we're looking at now, is nothing. Linda?
I've had that happen, Bob. You know, where you're up there and you're trying to get things to work and they don't work, and then you feel like an idiot because you're supposed to be able to do this, and you have your help and you call them, and this is a live trial. That's what happens in a live trial. Things don't work like you planned them, and that can endear you to a jury, or the jury can get kind of teed off with you, depending.
Gosh, while we're waiting for that, I got to tell you the funniest thing ever happened to me in court. I was trying a case with my father, and he had to bend over because something kept falling off an easel, and his suspenders snapped in front of the jury, and they laughed hysterically, and there was no doubt in our mind that we had the jury from that point on. They loved them.
Yeah. So now we're watching some of the video that the prosecution has compiled.
In this video, for our Sirius XM listeners and for our viewers, so you get it, this is a montage that was created by the video audio expert for the prosecution, and you see a snowy road, there's a parking lot, there's a street off to the left, and it's really grainy and almost looks like a pixelated, really dark picture, although you can see a lot of snow, and you don't see a lot of activity right now. Now we're seeing another shot on what they're calling Channel 4. This is what was actually being played inside the courtroom. And again, Linda, I don't know. I thought a lot of the video that was being presented wasn't necessary. Right now, though, you're seeing something that's two people casually walking down the street. The snow is really high on both sides of the sidewalk. You're seeing a man now back away in a quick, furtive fashion, if you will, and a car now coming down the road with headlights towards that person who was backing away. Again, this is what was being shown in court, and I'm not really sure the jurors were getting it at the time that this was all being shown. What are your thoughts?
And you know, you see why they couldn't do much more with the video. For those of us who can't see this video, it is very grainy, very you really can't make out colors. You can make out something light or dark, and apparently that's the shooting that we're watching right there, and seeing that shooting, which is still remarkable.
Yeah, we're going to get to another good clip now. But what I found interesting, and I'm really curious what our viewers who've been watching this trial assiduously think. The prosecutor introduced that evidence, but the victim never testified about it at trial. This expert came on after the victim testimony. I, as a prosecutor, would have not only liked to have given and narrated his whole story, the victim, Luis Rodriguez, that you just saw testifying, but even from a point of repeating over and over again that testimony, then show the video and ask him to narrate the actual shooting of himself. I thought that would have been a very powerful tool.
Yeah, I don't know why. There's some reason why. We don't know what it is, but sure, that would be a powerful tool. Unless he's going to say he doesn't really remember, except that he was shot in the head, and that may be the issue, that he doesn't remember a lot of it at that point, because you recall that he said he didn't know on some of the things, and maybe the prosecution doesn't want him to be cross-examined on. Well, you could see the Reverend's face turned around here, couldn't you? Why couldn't you identify him then? Things like that. But I think I'm with you, Bob. I would have had him narrate the video.
Yeah, I mean, he could have, at least at a minimum, said, there we were walking down the street. I didn't know that there was anything wrong. And from that point, when the person starts to walk the other way, supposedly the Reverend, or move quickly the other way, hey, I couldn't tell you I was lying in a pool of blood. Which gets us to our next point. The victim had testified that some of the reasons why he didn't identify the Reverend, or maybe didn't give the responses that you would imagine, is because he had a bullet in his head and he was dazed, disoriented, and in shock. And in fact, there was a first responder that came to the scene, and there was some pretty dramatic testimony of that first responder. Having been a first responder myself, you come onto these kind of scenes and it's like mayhem. So it'll be really interesting to listen to what that first responder has to say. So let's go to that clip, and we'll come back with Linda Kenney Baden at the other end on the Law&Crime Network. Well, welcome to the Law&Crime Network and to our Sirius XM listeners. Hey, this is a Dan Abrams production. This is a live trial network where we do it from beginning to end. No sound bites. We listen to all the testimony, and we have great experts like Linda Kenney Baden, who's with us today, former prosecutor, defense lawyer, Jersey girl, makeup artist, great cook, great to hang out with. And listen, Linda, you give great analysis too. You make my job very easy, and you could tell that our people online love what we're doing here and love your analysis. So please keep the commentary coming, folks. Started out with @R Bianchi ESQ so I can see it real quick. So we just listened to the first responder there, and it's kind of interesting in juxtaposition to the cross-examination of the 17-year-old boy in the Sean Harrison case, who was being accused of 51 years old, shooting the 17-year-old boy as a result of a drug-related transaction. And the cross-examination by the defense attorney for Mr. Harrison was, well, to the young man, why didn't you tell him it was the Reverend that did this to you? And now we're listening to one of the first responders at the scene. I think it's a good move by the prosecution to bring that out, to show that there's a lot of hecticness, mayhem, the kid's been shot. It's not likely you're going to get into a full dissertation or have the analytics that you would in a courtroom years later. What are your thoughts?
Well, Bob, when I watched this first responder, I'm on the prosecution, I'm loving him for this reason. He answered two questions, right? He asked Mr. Luis, what happened? And the kid didn't know. Now, he's been shot in the head, but he didn't know. So that goes along with him not telling him right away that it was the Rev who shot him. The other thing, all he was concerned about is whether he was going to live or die. Can you imagine that? That's what he wanted. That's what was on his mind. Am I going to live or die, live or die, live or die? So I'm loving that. Now, if you're a defense attorney, you're going to say, well, if he thought he was going to die, he should be telling the truth and who shot him then. But that becomes pretty callous when you have this type of testimony.
Yeah, I don't disagree. Listen, Linda Kenney Baden, prosecutor, former prosecutor, defense lawyer, just like myself, same kind of similar career, Jersey girl, I've got to mention that's important. Right. Listen, this is, I agree, I think that it resonates with a juror that the first thing that goes through your mind after a bullet goes through your mind is whether you're going to live or die, not necessarily identify who did this to you. It certainly is a good point for the defense to bring out, but with all the other evidence, I'm not sure it's going to make the day. So we're going to throw to a commercial break. When we come on the other end of that, we're going to recap this case a little bit, maybe have a little back and forth between me and Linda, and then we have another clip ready to show you that I think was powerful that the prosecution put on. We'll be back right after this. Welcome back to the Law and Crime Network, and welcome to our Sirius XM listeners. You know, Linda, we were just talking before we did the top crime stories that not only is this a great network because you can listen to everything from the beginning to end and get some real great expert opinion from people like yourself, but I got to give a shout out there to these producers, the camera people, the control room, and we have these little earpieces that are going in, and they are constantly working. I mean, I do a lot of media, but I got to tell you, these guys are really squared away. The people in the back writing the stories, getting us the data. It's just really an amazing crew. I know you do a lot in the media world. What are your thoughts about that?
Amazing crew, absolutely. They're the best. Dan Abrams has done a great job with this network, but it helps to have hosts like you.
Oh, well, thank you very much, and it helps to have people put my makeup on like you, and also be able to answer those great questions. Linda, we're at the Sean Harrison case here, and it's out of Boston, one of your old haunting grounds. I believe you've actually probably been in that courtroom, and this is a fascinating case. It's a question: is it a double life? Is it a Jekyll and Hyde? Is this man 51 years old, a youth counselor and trying to do anti-gang, drug, and gun stuff? Or is he, in fact, a double agent, a veil over him, and one thing in the public, but actually soliciting juveniles and youth and drug distribution schemes that ultimately led, the state alleges, to the shooting of a 17-year-old boy, Mr. Luis Rodriguez, who actually lived, survived, testified. We've been watching those clips. We watched the first responders clip. And, Linda, I think so far the prosecution's put on some good witnesses. I don't think either Mr. Rodriguez or certainly the first responder who was a police officer got hurt at all, really, in any real way. But we also have Sharice Strickland, who was a passerby, who actually made a 911 call. There's some interesting little anecdotal evidence that came out. Don't forget, if you're a good prosecutor, you don't put on any witness unless you need something from them. Otherwise, the old adage, Linda, if you stand well, stand still. Don't mess it up. Let's take a listen to her testimony.
What were you doing that evening around 7 p.m.?
Me and Jeffrey Bullock were heading to Olive Garden, South Bay.
And you were going from where to the Olive Garden? Where were you? Just the general area?
Of Dorchester.
And at some point, did you drive down Magazine Street?
Yes.
What happened as you were driving down Magazine Street?
As we were driving down Magazine Street, someone walked into the street and flagged us down to pull over.
Who was driving the car that night?
Jeffrey Bullock.
What kind of car?
A Jeep Compass.
That person that walked into the street and flagged you down, can you describe what that person looked like?
It was a young teenager, Hispanic background.
Did you notice anything else about him?
He was bleeding from his ear.
How much blood are we talking about?
Lots of blood coming down onto his clothes.
Which way did he come? He stepped in front of you as you were driving down the road?
He stepped in front of our car and flagged us down.
Okay. Did Mr. Bullock stop the car?
Yes.
When he stopped the car, what happened next?
That's when the person approached our car window on my passenger side, and I cracked it for him to talk to us.
Cracked it how far?
About 2 inches.
Why did you only crack it 2 inches?
I wanted to be able to hear him, but not for him to be able to do anything else because I didn't know who he was.
Have you been down Magazine Street before?
Yes.
What type of area is that generally?
Secluded, not really like a good neighborhood.
So how did this person who was bleeding, who approached you, make you feel at the time?
Very scared and nervous.
What happens next?
He tells me that he believes he just got shot and that he doesn't want to die.
Was there anybody else on scene, or was it just you and Jeffrey?
Just me and Jeffrey.
What happens next?
I called the police for somebody to come and rescue him.
Welcome to the Law and Crime Network and to our Sirius XM listeners. So we're listening to the testimony of Ms. Strickland, who was talking about having come up on the scene and having ultimately made a 911 call that led the law enforcement authorities to the scene of the Sean Harrison attempted murder case. This is out of Boston. 51-year-old pastor is accused of having shot a 17-and-a-half-year-old in the head, who we listened previously testified because he lived, and being part of a drug distribution scheme, a double persona, if you will, a person who is supposedly a great community leader, work with the police, an anti-gun and drug and gang guy, who they're saying really the prosecutors was doing those very things and cultivating and soliciting these teens for his own profit. And there have been significant pieces of evidence, but we are actually at the crime-solving piece of this. This witness is testifying about rolling up on a scene and seeing a horrific thing. Linda, do you think her testimony was necessary and needed by the prosecution?
Absolutely. This is ordinary people in extraordinary circumstances, and this is what happens when I'm sure when she went out for dinner tonight with her boyfriend Jeremy, at that night, Ms. Strickland didn't intend to come upon a man who was shot in the head, but she did, and she immediately called 911. And this just goes to show you the human aspect of what goes on into these cases, and the fact, again, reiterates that he's bleeding and that he's upset and that he's incoherent in a way because he just got shot. So I think this is very, very important testimony to discuss exactly what happens. And I listened to you, Bob, by the way. I was listening to you just like the prosecutor should listen and the defense attorney should listen. You said this was a case about a youth counselor. And sure, if you listen to the prosecution, he was counseling youth into crime and then got a shot in the head.
Yeah, definitely. And, you know, Linda, getting back to a little bit, and I don't disagree with you, a little bit of this testimony here, you know, as a prosecutor, just to let our Sirius XM listeners and our Law&Crime faithful that are blogging here know, you know, sometimes as a prosecutor, it may not go directly to the guilt. It may not establish identity. It doesn't establish, certainly, she doesn't know Ms. Strickland, the crime distribution scheme that's being alleged here by the prosecution, but it brings drama to the crime scene, and it actually kind of shocks the conscience of the jury to say, hey, guys, this case is not happening inside this courtroom. In the courtroom, it's antiseptic. In the courtroom, you're listening to testimony, but let's give you real live people, first responders, and people who are witnessing a startling event to kind of shock them into the seriousness of this. So it may not go directly towards guilt, but it kind of redirects that jury's attention to dramatic testimony. What are your thoughts?
And also, think about this. She's going to dinner, but she can't really get out and help him. She has to just roll her window down halfway because she's concerned about whether or not there's a crime going on. Think about that. The juror has that impact. That, yes, that would what I'd be doing in that situation. And isn't it terrible? But you have to know that having been in Boston and tried the Aaron Hernandez case with all the co-counsel that we had, that we were in Roxbury a number of times, and Roxbury has had a number of crime acts and is considered a gang area according to some of the Boston police that we had to cross-examine. So that's probably why she may have been worried about whether her safety when coming upon this young man who was shot.
All right, excellent. Well, we're going to be listening to this 911 call shortly, but apparently I'm learning from being online from our great producers that I am using the term bloggers for our people who are writing commentary on here, and I'm not sure why that's laughable, but apparently I'm not using the right term. So whether you're bloggers, whether you're writers, whatever it is that you're called, I'll get the right name eventually, but apparently people love this, Linda. We do appreciate the comments, whatever your term is. They're really helpful to us to not only bring them out, but also some great insights in those questions. So we're going to listen to this 911 tape, and thank you, Kathy, by the way. You know who you are, because I know that you're doing a lot of that laughing, and I take it all in stride. Listen, we've been around the block too much to get upset about anything pretty much at this point, Linda.
No, usually people send hate mail to me, so it's okay.
Yeah,
fine.
Exactly. So, listen, I love being on this network, and I love having this interaction with great folks like you in great cases. We're going to listen to the 911 call made by Ms. Strickland, and on the other end, we're going to come back. Listen for the drama of this call. Let me know when you're online, whether you're bloggers or whatever you're called, whether you think this would have an impact on you if you were a juror.
911, this call is recorded. Operator 388. Honey, I'm down.
Ma'am, I'm just going to pause it right there for one moment. There was a 911 operator, is that right?
Yes.
And the second voice on there, is that your voice?
Yes.
Okay. Hello?
Hi, I'm on Magazine Street. Somebody just got shot. He's right here with me.
What number magazine or cross street?
What number? Where are we?
Hello, what? Give me a cross street, ma'am.
What cross street are we at? What are we next to? What building?
Magazine in Norfolk Street.
Magazine, Norfolk Street. He's bleeding a lot. Honey, I'm calling 911. Yep.
Okay, stay on the line with me, okay?
Yeah.
Let me get the call in.
Okay.
Okay, did anybody see anything?
Oh, fuck. No, he's bleeding really bad.
Where is he shot?
He's shot in his face.
In his face?
Yes. He's bleeding really bad.
Did anybody see who did it?
No, just come, please come.
The call's already in, ma'am, but I need information.
Okay. Did anybody see you? Did anybody see you get shot? No.
Any cause, anybody? And
No,
nothing
no,
at all?
we're the first person.
Okay, what's your first name, ma'am?
What was that?
Your first name, please.
Cherise.
All right, they're on their way.
Thank you so much.
You're welcome.
All right.
9.
After you made 911, the 911 call, how long did it take for police to arrive on scene?
5 minutes.
And were you having conversations with him at the time?
Yes.
Did you ever get out of the car?
No.
Who got out of the car?
Jeffrey Bullock.
Did he assist this young man?
Yes.
While you were in the car and Mr. Bullock was assisting him, what did you do?
Take a picture.
Take a picture of what?
I took a picture of the victim.
And I'm going to show you one photograph. Do you recognize that photograph?
Yes.
And what is that a photograph of?
Jeffrey Bullock checking on the victim as he bleeds from his ear.
And did you take that photograph?
Yes.
And is that a fair and accurate representation of what it looked like on March 3rd of 2015?
Yes.
Show you a second photograph. Do you recognize that photograph?
Yes.
What is that a photograph of?
The victim sitting down, bleeding from his ear, a better view of his face.
And the gentleman whose back is turned us on the right-hand side, who is
Jeffrey
that?
Bullock.
Welcome to the Law and Crime Network and to our Sirius XM listeners. You're listening to the testimony of Miss Strickland, who was the person who came up on the scene and made that 911 call and is now answering more questions. And we're going to get back to that in a minute. I'm with my great guest, Linda Kenney Baden. And listen, I got a little bit of a dispute already here, just to take a little sidebar, that I'm being advised now by the people on this line that you just call them viewers. I know they're viewing Linda Kenney Baden, but they're when they're putting the stuff on the typing there, to me, they're chatting or blogging, right? I don't know.
Blogging is they're chatting right here in the chat box. They're using a chat box right now. But they're also watching, I hope, except for if you're on Sirius, you're listening.
All right, the way I'm looking at this is if you are watching right now, you are watching me, you are a viewer. If you go to your computer screen and you start typing, you are either a chatter or a blogger. That's going to be my defense to this case. I want you to represent me, Linda.
Okay. We have to give you some internet education and etiquette, I think.
Yeah, listen, all kidding aside here, BB314, who is one of our viewer, chatter, blogger guys or people, asked a very interesting question. We were talking about this off set with a couple of folks before you got here, and I think it's a really powerful question. No defense witnesses in the case. Linda, I was really expecting with a guy with this kind of background that the defense would have had a massive list of character witnesses that they may have brought into the courtroom because, as you know, the judge will read a charge. In most states, I'm pretty confident Massachusetts is the same, that a jury can find a defendant guilty irrespective of all of the evidence presented by the prosecution on character evidence alone. I think BB314 is asking a really insightful question. Why do you think it was that they didn't call one for a guy with this impeccable background?
Because if you open up character evidence, then you open up character evidence for everything, including people that may have known him that have bad character evidence. And so it just becomes a dangerous thing. You can't even say anymore that you put a priest on with character witnesses because they, the jurors don't look at priests, they look at them as child molesters in some cases, right? Especially in Boston, where they broke that big story. So character testimony can be, I don't like it. I really don't like it.
Yeah, Linda's bringing up a very important point. It is true that if you bring up character testimony, you are subjecting those witnesses to cross-examination, to limitations of whether or not their opinion of his reputation would be affected if you had known, and they can bring up under limited circumstances. But, I mean, it could be the defense knew that there was some outside evidence outside of this trial that may have walloped them, but boy, I'd love to know the behind-the-scenes thing with that.
And the next question is, why didn't he testify? He's a reverend. He's got all these incredible historical issues in terms of being anti-gang, etc. But the problem you have there is if you think the prosecution didn't prove the high crime of murder, and the jury's going to be that's the issue they're going to be debating. They're not going to be debating anything else. I can tell you that right now. If they don't believe they proved that, then you don't ever want to put your defendant on the stand because then it all becomes about them. Anything else you did as as a defense attorney is gone. Goodbye. Wave it goodbye. So long. Farewell. It's only about them. And I know you would love to have a defendant.
I salivated as a prosecutor. I love cross-examining defendants, but you're making a very good point. Right now, you can talk about reasonable doubt, but what a good, skilled prosecutor will do, very rarely you're going to get a defendant that's going to get up there and say, I did it, oh my God, you got me. That's not realistic. But as a prosecutor, I know at a minimum on cross-examination, Linda, if he doesn't slip up, I can at least do this. I can introduce my state's case and all the witnesses through him on cross-examination. And even if he disagrees with me 1,000 times, well, those drugs were in your house, you can't disagree with that. That's a fact. Well, they weren't mine. And that gun was in your house, you can't disagree. And that ammo was in your house, and you know, all the ledger was in your house. And he can sit there and make every explanation he wants. But what I'm doing is, my favorite term, looping testimony from my direct case as a prosecutor through him. Now, that's the basic way to do things. If you can get him to start answering questions and he starts tripping himself up, or her, well, in this case, Sean Harrison, Mr. Harrison, I go back to what my boss, my mentor told me, that as a prosecutor, juries love to convict defendants from the testimony out of the mouths themselves. It's the most comfortable place for jurors to do that. So you risk a lot by putting a defendant on the witness stand, guilty or innocent.
Now there is one exception to that. I would suggest that if you have somebody accused of child molestation or child abuse, and you really think they're not guilty, okay, and you believe you have an innocent client, you have to put them on the stand, in my opinion, because the jury has to see the person and assess them, because right now they hate them. If they don't get on the stand, they're just going to assume they're guilty. And that may be the only exception.
Yeah, and of course, we've seen this, and it's tactically confusing, but a good tactical lawyer, in my mind, doesn't even make a decision as to whether a defendant's going to take a stand well into the government's case.
Or right until they're about to testify. I mean, you have to assess that on a constant basis, but you're usually going to assess it that they're not going to testify. You're assessing it, but, you know, you're usually going to say they're probably not going to testify.
Yeah, and the reason I just bring that up, that you wait to that length of period of time, is that I'm seeing with more and more frequency trends going on in trial that are a little confounding to me, and one of them is opening statements by defense attorneys where they're saying their client is going to take the stand before the testimonies even come out. Very premature in my mind, and dangerous. But listen, folks, I love listening and talking with Linda, great expert in this area as a prosecutor and defense attorney. And we're going to take a short break and come back to you with some great Law and Crime Network trial stuff that we got. We're on Verdict Watch in the Sean Harrison case. We've just been discussing this 51-year-old reverend who was accused of shooting that 17-and-a-half-year-old boy and involved in an alleged drug transaction. He's on trial for his life here. The question is, was he leading a double life and was actually, I guess, predator, if you will, of children, preying upon them and their vulnerabilities and their lack of maybe family structure and socioeconomic circumstances to assist him in a drug distribution scheme? Or is he just the patsy, the fall guy, and all this evidence is either planted or explainable, but he is, in fact, that man the community believes him to be? It's going to be a fascinating verdict. We'll be back on the other side of this break. Welcome back to the Law and Crime Network and to our Sirius XM listeners. I'm here with Kenney Baden. We've been going over the Sean Harrison case. We are on Verdict Watch, and this fascinating case of a double life, at least as alleged by the prosecution, as to whether or not he was actually a person trying to help the youth with regard to anti-gang, gun, and drugs, or whether or not he was a sheep in wolf's clothing and was actually soliciting juveniles in drug distribution schemes, and ultimately he's alleged to have shot and attempted to kill a 17-year-old boy, Mr. Rodriguez, who we've been listening to testimony earlier, in the head, who lived to tell his tale in court. Now, Linda, we've been going through an ongoing debate. I've asked you to be my defense attorney. I am told by the great Kathy Russin of the Law and Crime Network that it is viewers, and viewers is what I'm going with. So you viewers keep those questions and commentary going. I am pleading guilty to having inappropriately used bloggers beyond a reasonable doubt. I'm sorry. Thank you for your opportunity to represent me, but I must admit guilt, given the compelling evidence of Miss Russin. What do you think?
What can I say? What can I say? You would have been my favorite client of all time if I could represent you.
Can I throw myself on the mercy of the network? All right, listen, guys. It's been great breaking this trial down with you. And Linda was supposed to leave at 2 o'clock, but she's not only been putting my makeup on and giving me great legal analysis here, but she's agreed to stay till 3 today. I was really excited yesterday when I learned you were the guest. I'm even more excited that you're going to stay that extra hour, Because,
Only for you.
Thank you, thank you. And I promised you I had to give you something in return, and we're going to do that sometime in New York one of these days and go out and enjoy Joe's company on a personal level. But listen, guys.
With our spouses, you don't want anyone to get there wrong.
Amen. I don't go anywhere without my spouse and or my dog, Holly, the legal beagle.
I'll bring Valjean, too, my dog.
All right, awesome, awesome. Hey, guys, we're in this testimony right now, and the prosecutor's building blocks of this case are not just the drugs and the weapons that were found inside the home of Mr. Harrison, Mr. Sean Harrison, but also some anecdotal testimony, of course, big testimony from the victim. But we listened to the 911 call that was made by the young woman, Ms. Strickland, that came onto the scene, and that's always good evidence. That can't hurt you as a prosecutor. But we're also going to listen, and I think this is really an important witness, to Kevin Perez. He was a student at the time, and he's going to talk about how he was being solicited, or others were being solicited, to actually assault Mr. Rodriguez. That's the young boy who was ultimately shot in the head, and actually trying to engage that Mr. Harrison, the defendant, was trying to engage people to fight him in school. I guess it begs, Linda Kenney Baden, the obvious question, rhetorical. Why would you be doing that if you're this great guy?
Right. Well, rhetorical answer. He's not a great guy, obviously. I mean, he is stroking these students. He is patting them. He's just like a sexual abuser, isn't he? He tries to get them to do his bidding through them. He's really a coward. I mean, when you come down to it, if these stories are true.
Yeah, and the prosecution was never able to give a quote-unquote completely solid motive. I mean, so it's drug-related, but I think that this is really good because it's kind of like grooming. It's predatory in the sense that a message was trying to be sent, the prosecution is arguing, by Mr. Harrison, 51 years old, to this 17-year-old boy. And whatever this dispute or problem was not rectified or resolved, when in fact we saw a video of the young boy, Mr. Rodriguez, actually getting slammed into a bathroom by somebody.
Terrible.
So whatever occurred wasn't enough, didn't settle the debt, didn't settle the problem, and that's the state is using, that he took it to the next level. So let's listen to the testimony from this young man, Mr. Perez, the student, because I think it was pretty important.
When did you
Welcome back to the Law and Crime Network and to our Sirius XM listeners and Law and Crime Network viewers. We were here with Linda Kenney Baden. We're listening to this testimony now of the argument, or actually Mr. I'm forgetting his name right now, Mr. Perez, Kevin Perez, who is indicating that he went into the school, spoke to Mr. Sean Harrison, who's being accused of attempted murder and assault of Mr. Luis Rodriguez, and that he asked, Mr. Harrison asked Luis if he would fight him, and he said no, and he indicated that it was because Luis owes him money, and he also asked him during the course of that conversation if he would be willing to sell marijuana for Mr. Harrison. You know, pretty tough testimony for the defendant.
Right, and he also tried to solicit someone named Loudy to also attack Luis, to try to hurt him. And again, here you have the motive that apparently Luis owed him money for marijuana because he thought that Luis had stolen marijuana from him. So there you have a motive. It's all wrapped up in this nice little, if you believe Kevin Perez, you have the motive and you have the reason and you have solicitation and you also have him grooming and you have the fact that he's trying to get other people to sell marijuana from this nice little witness, if you believe him.
Yeah, and if you believe him, and it all comes down to the credibility of these witnesses, but now you have the victim that really would have little bias in my mind unless you can establish it to misidentify the person that shot him, and you have this gentleman, and you have all that stuff that was found in Mr. Harrison's, Sean Harrison's house. I mean, these building blocks just start to add up, and I don't know if the credibility of this gentleman is going to really make a difference, because I think the jurors are going to say it's yet another thing in a chain of things, but probably perhaps, in my mind, most important are the text messages sent from Sean Harrison himself, which are just so inconsistent with guilt. And you can't argue the credibility of this young boy or that young boy. These are coming from your client, and they're not good. Pray for me and get out, and you know, all these kind of like squirrely and odd statements that are being made. That, do you know where he lives? He's telling the police, and Mr. Harrison says, no, I don't know where Luis lives, and that becomes a demonstrable lie. There's a lot of deception in this case coming from the mouth of the defendant himself, and a lot of statements of the defendant coming through witnesses like this young man, which you typically don't see in cases like this, Linda.
Yes, but what you have here is somebody that he's actually soliciting, who also could be a part of this conspiracy when you think about it, right? Because it's coming directly from him. It's an admission, it's a statement against his interest, so it comes into evidence, even though it's hearsay, because it can be reliable because it is a statement against interest.
Right. So wow, you really threw that bad boy out there real fast. Statement against interest.
Well, it's kind of a statement against interest. It's against it, but it's coming. It's a statement against his interest, but it's coming through a third party who could be a conspirator.
Yeah, because one of the viewers had noted, and I had read the commentary about, like, why are these people being allowed to talk about it? Isn't this hearsay? It's not a bad conversation to have. It's
Absolutely.
a really important question. You got to know those evidence rules, right? Every state has them. They're basically the same in each state, but those evidence rules are the playing field, and I can't count how many times I have been on trial and a lawyer was convinced that they were going to win a case, and I'm objecting to the introduction of the evidence because it violates the evidence rules, and the judge says agreed, and then all of a sudden they get blindsided, not realizing they can't introduce it. Hey, if you can't get it before the jury, if you can't get it in court, you might as well not have it at all. So what Linda's talking about are the hearsay rules, which are out-of-court statements used to prove the truth of that statement in a courtroom. There's a lot in that.
There's a lot what you just said, yeah. And judges have a problem with it too, and lawyers have a problem with it. Sometimes they don't know when something is admissible or whether it may be admissible, it may not be admissible, but this is definitely admissible in my opinion. This was coming in right from day one.
And what Linda had talked about was a thing called statement against interest, and that is what they call an exception to the hearsay rule. It is clearly a hearsay statement when somebody is telling you, like this young man is, that Mr. Harrison told me. You know, when somebody's telling you what somebody else told them, your hearsay flag should go off.
Ding, ding, ding.
Ding,
absolutely.
ding, ding.
Absolutely.
But there's so many exceptions to that rule, Linda, and the admission against interest is one in which they're basically saying people would not make admissions to things that expose them to criminal liability or civil wrongdoing. That people typically don't do that, so there's an inherent reliability in allowing that statement to be introduced in evidence, and that's what you meant by statement against interest or admission.
Right, and you want something reliable. You don't want the jury to base their findings on unreliable evidence. We know that. Look at all the exonerations that have happened over the years with the Innocence Project because the juries had unreliable evidence. So you really want, if you're a good ethical prosecutor like you were, Bob, reliable evidence, and you're a defense attorney, you're trying to keep the unreliable evidence out also. You just want to go to that jury with reliable evidence, whatever side it is.
Yeah, and you bring up a great point about as a prosecutor, and I like to think I was an extremely honorable person that way, and I think most of us prosecutors are. And one of the things is it's not just putting the evidence in. There was a theory, Linda, that used to go around in the old school days when I was a young assistant prosecutor. Throw everything you got against the wall,
right.
and wherever it lands,
Yeah.
and let the jury make the call. I don't agree with that at all. There's a lot of times that you have evidence, maybe even really damaging evidence to the defense, but as a prosecutor, you got to also try that case to success on appeal, and that evidence may be legally wobbly or they're legally challenging, like bad act evidence or things that really sully the reputation and character of the defendant. And as a prosecutor, you got to do a cost-benefit analysis and sometimes say, yikes, this will really put a stake through the heart of this defendant, but will I survive appeal? And perhaps it's better not to introduce it so I have a more solid conviction. That's what good prosecutors do.
Even more. Remember, that jury goes home at night. We bandy these terms around. People that watch the network, listen to the network, are used to it. We're talking about it. But when you get those jurors in there, they're not used to this. This can give them post-traumatic stress disorder. If they have to decide the fate of a person on some evidence that could have two different meanings. So hopefully you have good evidence before them, whatever side you're on. But this is a very traumatic situation. I mean, if I'm in there discussing this murder case against him, I'm torn right now.
Right, and I think that's a really good point that you're making, that as a prosecutor especially, you have to recognize that you're asking the jurors to do a monumental thing, and I don't care how much people are into law and order or what have you. When you're ultimately responsible for what we would call push the button of guilt on a person and either take their liberty away for a substantial time, your obligation as a prosecutor, this is what we used to say, or I used to, I learned it from somebody else, I passed it on, you better put it in a box, put a nice lid on that box, wrap it up, a great gift, wrapping, nice bow on it. You need to hand them something that is really solid so they have a comfort level to know they did the right thing. And sometimes that gets lost about the psychology of what's going on with these jurors.
That's right, and they follow the law beyond a reasonable doubt. That's the law.
Yep. And so the burden is meant to be difficult. It should be difficult. We're now analyzing. We're going to throw to a break in a minute, but we're analyzing the Sean Harrison trial out of Boston, Massachusetts. 51-year-old pastor and youth guidance counselor, as Linda would put it. Well, what exactly was he guiding? Was he guiding them to be anti-drug and gun, or was actually a person facilitating the use of drugs and guns? That's what this trial is about. Was he leading a double life, and did that ultimately cause him to shoot a 17-and-a-half-year-old boy in the head? We're on verdict watch. We're going to come back on the other side of the break and do some more analysis with our great guest. Welcome to the Law&Crime Network, and congratulations to Linda Kenney Baden. She's like nailing it with regard to like using these juveniles in a drug distribution scheme. And here you go again with this young man, not only talking about marijuana and talking about soliciting an assault of this guy, but knives and yeah. So I mean, this gets right to your point about. I guess a sentiment that maybe jurors would have, or the prosecution's trying to say, that this is a man who's out in the public. We're at the Sean Harrison trial, who's supposed to be a 51-year-old minister and an anti-gun, drug, and gang guy, but yet he's engaging in behavior with kids he's supposed to be protecting with regard to drugs and knives, and if you're going to believe the testimony of this witness, orchestrating the assault that we saw on video for our Sirius XM listeners. It's a pretty dramatic video of the kid walking down the hallway and just being like blindsided through.
But the problem is, it's this witness, right, who's hitting him, right, who's jumping on him.
Yeah.
So that's all that. But that's a problem for the prosecution, or is it? Because if you're the reverend, you're going to get the kids that you've groomed, as you use the word so appropriately, to attack another kid. And you also want to show, if you're the reverend, that you have this drug operation, that you're not afraid to attack people, right? And maybe he said that the reverend said he was going to shoot Lewis that night. That's going to be, I assume, where the defense is going to cross-examine, because is that a believable statement? I don't know. Maybe it is, because maybe, again, if you're the reverend who's Dr. Jekyll, Mr. Hyde, you want to show you're tough. And if you're going to play with me and you're going to steal my marijuana, I'm going to get you all the time.
Yeah, you bring up a good point, and I wanted to bring that up earlier. And in drug-related transactions, and it may not be something that you can get out evidentially, but you hope a jury gets it, there is a level, your expert could have testified to this, but I don't think they went there, that you need to let them know you mean business. And most people could sit there and say, would you kill somebody because you're a couple of joints short or not? Well, maybe you wouldn't have done that, but maybe you'd commit this assault. And if it happened again, you need to send a message out there, and it's got to be clear, otherwise you're going to get eaten alive by other people who are going to think you're weak. And that happens a lot in the drug trade. And I mean, it sounds almost unbelievable that a 51-year-old man who's working at a school would be engaging in this activity. But, when you've been doing this long enough, Linda, greed and hatred and jealousy and anger, the things that motivate people to do some really bad stuff. And this seems pretty calculated in this particular case.
And remember, we talked about this. This is Boston, where you had the spotlight, which uncovered all the sexual abuse in the diocese up there. So these jurors are aware of that. And the same kind of grooming pattern here, where you're taking kids who are at risk and you're using them for your own purposes. The jurors are going to understand that this can happen, even in a school, even by somebody who calls themselves the Rev, even by somebody who's in a position of trust. It can happen.
Right. So our last point before we go to a little bit more of this testimony, in my mind, is that because of the issues that Linda is bringing up and the potential credibility attack of this young man, I mean, it exists. As prosecutors, we have to put sometimes bad people on the witness stand in order to prove our case, or people that have done bad things, for that matter. But you want to be able to support that with objective evidence. And we got, Linda, we got drugs, guns, ammo inside of that house, cash, ledgers, and we also have those very interesting text messages. I think that's a really high mountain for the Reverend to overcome. But let's listen to some more of this young man's testimony and see if our viewers believe. Let me know your commentary here. Feel free to put it on here. We're the only live trial network that allows us to be able to do this and give this commentary. Do you believe this young kid? If you don't, did he hurt the prosecution's case, or is the other evidence supportive of what he's testifying to? Let's listen and talk about it on the other end. Welcome back to the Law&Crime Network. And for our viewers, as well as our Sirius XM listeners, love having you on board. I got the great Kenney Baden, who's been with me for the last 3 hours, breaking down this case of State versus Harrison out of Boston, Massachusetts. It's in verdict watch right now. I mean, it's a fascinating case. Is he leading a double life or not? 51 years old. Is he this great anti-gun, drug, and gang guy? Or is, in fact, he leading the double life, as you've been listening to with this testimony, of being a person soliciting young kids from the school that he worked at in order to engage in a drug distribution network, ultimately resulting in the shooting of a 17-year-old boy, Mr. Rodriguez, and being charged now with attempted murder in addition to the weapons and drug offenses he's charged with. The boy testified, rather. He was giving compelling testimony. He obviously lived and pointing the finger at Mr. Harrison and saying he's the person who shot me. Significant amounts of drugs and money and ledgers and other paraphernalia were found inside Mr. Harrison's home, and the defense is basically trying to say this is all basically a plot. It's all made up. It's all supposition. I think that there have been a number of things, Linda. I'm curious about your opinion overall. We've talked about text messages today that weren't necessarily flattering to the defendant. These witnesses, even this young man, a little more salty than the victim, but I don't think the defense is scoring much points. So overall, how'd the prosecution do with the case, and do you have any thoughts about what's going to happen while we're on verdict watch?
Well, we'll look at this. Kevin Perez, he's a good witness to the prosecution. The defense is saying, well, you didn't go snitch on these people to the police, but so what? This is a crime network. This is a marijuana network. This is a drug distribution network. He wouldn't do that. So I think the prosecution has done a very good job on this case. I think these kid victims are very, very compelling.
Yeah, and the only one question that we got, and I'm going to try to look this up. I even want to reach out there and find out why didn't the prosecution show this victim those surveillance tapes and have the victim identify that this is me and this is Mr. Harrison. It was just an interesting tactical question that I want to be able to try and have an answer to when I come back, if I can, because it's not something that lawyers are actually putting on the record as to why they're doing something tactically or not. Right. I just found it interesting. Listen, Linda Kenney Baden is with us today. She stayed an extra hour longer than she was supposed to. It's always a great honor to be on the Law&Crime Network. Like I've said, it's a live trial network from stem to stern, from soup to nuts, however you want to call it. For our viewers and Sirius XM listeners, you get to listen to the trial from stem to stern and have great legal analysis like Linda gave to us. And I really want to again thank all of our viewers who are posting their comments. They're greatly appreciated. And to the producers at the Law&Crime Network, at Dan Abrams Production, as well as all the guys in the back and the guys talking in our ears and the people doing the research. It's really a great honor to be a part of this, and I hope that you will wait for our next host that's coming on here. He'll be taking the 3 to 5 p.m. shift with regard to verdict watch in this and other matters. The great Jesse Weber, good friend. We look forward to seeing you again shortly on the Law&Crime Network. And again, to Linda Kenney Baden, thank you so much for your participation. Look forward to seeing you soon.